Welcome to week 2 of civil litigation, and please, if you have not subscribed, please like, subscribe, share and comment, because on this channel we bring you all the analysis of your workshop in both intakes, and also shall give you tips on how you can pass the oral exams. So we are dealing with civil litigation, and basically this is week 2 of term 1. So this will be the second week of civil litigation in term 1. During the week, students will be exposed to procedures subsequent to the institution of suits prior to the hearings. By the end of this module, you will be able to explain processes subsequent to service of summons. So basically, we looked at service of summons under Order 5 of the CPR, and we say that you must serve summons within 21 days. But you can apply for extension of time of 15 days in case you have not been able to serve summons within the stipulated time. So after you have served summons, then there we shall see filing of defenses and reprise to defenses. So basically, after you as a defendant have been served summons under Order 5, Rule 2 of the CPR, you have to file a defense under Order 8. So basically, when you look at Order 8, they give you that you have I think 21 days within which to file what? A defense. So after having been served with summons, then you have to file what we call, you have to file a defense. So after filing a defense, then that's when you have appearance in court. Remember, you don't have appearance if you have not filed a defense. So basically, you look at Order 5 for the time of serving summons, and also you go and look at Order 8 for which time are you allowed to file the defense, and also Order 9 gives you different types of defenses. So illustrates defenses and reprise to the defenses. Illustrates the application of default interlocutory and ex parte judgments. So basically, when you look at Order 9, I think Rule 20, 22, and 27, they talk about ex parte, default, interlocutory judgment, as well as default judgment. So a default judgment arises where a person does not file a written statement of defense. That one is called a default judgment under Order 9, Rule 6, 7, and 8. Then also have an interlocutory judgment, the one which is passed when there are pecuniary damages, liquidated pecuniary damages. Then ex parte judgments are the ones where the party doesn't enter appearance. So where the party does not enter appearance, we pass what we call ex parte judgments. So illustrate the process of taking out of summons for the elections. So we shall look at taking out of summons for the elections, and this is under Order 11. Under Order 11 of the CPR, that you must extract summons for the elections. So summons for the elections are extracted by the plaintiff, and basically here, because once you have served the defendant and the defendant extracted summons, then you have to proceed that you extract these summons. Then court can call you for a meeting, and then you agree on the documents, and also you set the date for a pre-trial scheduling conference. So basically, that's what we call the summons for the elections. So basically, here parties can seek from the registrar how the matter can be disposed of first. And in case you also have any other questions, like under what procedure, you can still consult the registrar at that very time. Then draft relevant documents in relation to processes subsequent service of summons. Of course, after service of summons, we file what we call an affidavit of service. And of course, the law governing affidavits is Order 19. So that means when you're going to file an affidavit of service, it's also an affidavit. So it must be fulfilling the requirements in Order 19 of the CPR. So, and then after that, after having filed the affidavit of service, you also proceed to extract summons for the elections. Extract summons for the elections, and then you appear before the registrar, who will give you further guidance. And then after that, you go for scheduling memorandum. And after scheduling memorandum, the matter begins the full hearing of the case. So we shall look at ESCO issues. The ESCO issues, of course, do not change, subject to a few modifications. You shouldn't be overcharging your clients. Duty of confidentiality, avoid conflict of interest, recusal in case for judicial officers where they think they are going to be conflict of interest, among others. So workshop 1, the workshop covers principles regarding service and non-service of processes within the stipulated period, obtaining and contested judgments, decrees where a defendant or respondent fails to take any essential step after receipt of the effective service, defenses, reprise, and answers pleadings, consequently filing of suits. So basically, once you have been served with summons and you don't take any step, we shall see what remedies are now available for the plaintiff. So learning outcomes: by the end of this workshop, students should be able to explain processes subsequent service of summons. We say that if you want to read the law governing summons, you have to read order 5 of the CPR, because it has the law governing summons. Then shall illustrate the filing of defenses and reprise to defenses. So basically, we can have a counter, because the defense, we can have a counter claim. I hope you have also looked at the counter claims, that a defense can also be a counter claim. It can be total denial, or maybe we can have total denial or a counter claim as some of the defenses we shall be looking at. But if you want to understand the law on defenses, read order 8 and 9 of the civil procedure rules. Draft relevant documents in relation to processes subsequent service of summons, recognize ISCO issues. So part A: this morning the managing director of Zara General Uganda Limited, Waraka James, came to your offices in relation to the following. On Saturday of February 2025, the receptionist or secretary at his office received documents marked A, signed on a written copy and stamped with company stamp. She kept them in her desk and only brought it to his attention on 21st of February 2025. So basically here, when you look at the document we have, it's basically the one annexed A. When you go here back to it's basically someone's filed defense. So we have a someone's filed defense, and this someone's filed defense was served on 22nd day of January 2024. So basically, if the summons were served on 22nd day of January 2024, of course the pleadings are there attached to have the plaint. We have the plaint. We have summary of evidence annexed there too, which form part of what we call a plaint. So now we have to understand, under order 8, how many days do you have to file a defense. And of course, when you go to order 8 rule 2, they are saying that order 8 rule 1, the defendant may, and if so required by the court at the time of issue of summons or at any time thereafter, shall, or before the first hearing or with such time as the court may prescribe, file his or her defense. So where defendant has been served with summons in the form prescribed, he or she shall, unless some other further order is made by a court, file his or her defense within 15 days. So basically, you file a defense within 15 days from the date of service of summons. And under order 5 rule 1, you serve summons within 21 days. But you can, with sufficient cause, you can apply to serve summons out of time within 15 days. So now the question would be, is this guy still within time? Because he was served, the summons were served on, as I can see here, the summons were served on 22nd. So definitely is out of time. So the remedy we are going to go here, advise Mr. Oraka on the steps to take to defend the company in the matter. You have to seek leave to file a defense out of time. That's when you can. That's how you can proceed, because already, like the way we have analyzed it, we can see that the person was served summons on 18th. So draft the necessary documents, effect the necessary actions So when you look at Order 8, Rule 20, they are saying that applications under Rule 18 of this order shall be summoned in chambers. So since we are under Order 1, Rule 8, that means going to be a notice of motion supported by an affidavit. So that the documents here are going to be a notice of motion supported by an affidavit, basically seeking leave to file a defense out of time. Part B, assume you are a lawyer with MC Mateus solicitors and advocates, and you have checked on ECMIS system of the High Court Commercial Division and found out that since the summons were served on the 3rd of February 2025, the company has not taken any actions. Advise on the possible ways of proceedings with the matter while specifying the most appropriate in the circumstances and draft the necessary documents. So if you have found, of course there are very many ways of how you can go about this. One, you can go for default judgment. We have expert judgment and interlocutory judgment. But here, by the fact that the most appropriate would be applying for expert judgment, because since they have not filed a defense, you proceed and ask the court that the matter proceeds ex parte. Because as you can see from the facts, you're saying that you are a lawyer with MC and you have checked on ECMIS and found out that since the summons were served on the 3rd of February 2025, the company has not taken any action. So you proceed that the matter proceed ex parte, and of course you must have an affidavit of service. So the document here would be applying that the matter be had ex parte, which is always the letter to the registrar. So assuming that summons were served on 5th February 2025, the managing director wants you to defend the matter. So that means if they are served on 5th February 2025, now we are 20 years. I don't know what was the intention of the examiner here, but seeing from above, it means that from the date of this coursework was issued, that means that it was still within time. So basically here would be to draft a written statement of defense, and under Order 8 and Order 9, so the document would be written statement of defense. So Part D1, assume that the managing director has informed you that the company found out that its driver was overspeeding and was actually the cause of the accident. However, the company is not sure of the expenses incurred by the plaintiff. He wants your firm to ensure that there is strict proof of the expenses. It illustrates the steps and actions would take in circumstances to protect the plaintiff's interest in the matter and draft the necessary documents. So basically they are saying that assume that the managing director has informed you that the company found out that its driver was overspeeding and was actually the cause of the accident. However, the company is not sure of the expenses incurred by the plaintiff. He wants your firm to ensure that there is strict proof of the expenses. So basically here, that means they can either go for judgment on admission. They can either go for judgment on admission or what we call consent judgment. So of course, that means they had to prove it and draft the necessary document. It would be maybe a letter to the other council, basically asking for proof. But since you now want to pay, we are looking at consent judgment or judgment on admission. As soon as the plaintiff took action and obtained a judgment in task 2, task 2 was about draft the necessary document, advise the possible ways of proceeding with the matter while specifying the most appropriate circumstance. Ex parte judgment. So it was about the ex parte judgment. Assuming that the plaintiff took action and obtained the judgment in task 2, illustrate the process you would undertake to protect the defendant interest in the matter. So basically here it would be the process of setting aside an ex parte judgment. It would be the process of setting aside an ex parte judgment because that's what we have been discussing at in task 2, and circumstances where an expert judgment can be set aside. When, for example, there was no failure to serve, where there was no service of summons, that's when you can set aside an expert judgment, the one which has been rendered, or when the other party was not absent. Yeah, so of course we need to do more research on task 4. Assume the managing director has informed you that the company found out that its driver was overspeeding and was actually the cause of the accident. However, the company is not sure the expenses incurred by the plaintiff. He wants your firm to ensure that there is a strict proof of the expenses. Illustrate the steps and action you will take in circumstances to protect the plaintiff's interest in the matter, and draft the necessary documents. So basically here, my mind is pointing me to, of course, the consent judgment, or maybe judgment on admission, where you have admitted the fact and want to pay. Then the court looks at those two scenarios, whether you can enter into a consent judgment or judgment on admission. But you have to write to the other lawyer, so as they bring proof of the expenses. So they must attach receipts. And then you can continue to do what we call a consent judgment, or maybe judgment on admission. Then that's when it's going to be. So basically that was it for workshop 1. So, but in case you want a detailed discussion based on cases and the law, you can inbox Matt or WhatsApp Matt 075 we discuss category B, prepare questions and answers, everything. So we shall save your time at the center. We shall make your journey easier. So in case you have the money but you don't have the time, we are the right people to come to. But also, in case you don't have the money, we understand. You can still pass the back course. As long as you use the time very well, because we assume that if you don't have the time, if you don't have the money, then you have the time. But most students have the money, but they don't have the time. Those are the students we are looking for. Then for you who don't have the money, use your time very well. To read. You can still pass the back course, because that's how we survived. We didn't have the money, but we used the time we had very well. So workshop number 2, this covers principles regarding obtaining orders for inspection of documents, discovery of documents, interrogatories, amendment of pleadings, and summons for the elections. So basically we are going to look at what we call inspection of documents. So this one arises, for example, in situations where you find that let me assume that you have sued the bank, and you are relying on maybe a mortgage deed, but the bank is the one which has the mortgage, and you have written to the bank and they have failed to give you the mortgage. So what you do, you proceed under order 10, where we have interrogatories, discoveries, and inspections. So interrogatories means you ask questions to the plaintiff on oath, whereas discoveries means you could be wanting to discover the document, or it could be inspection, you want to inspect the company's registrar. So you have to understand those terms as used under order 10 of the CPR. When you talk about interrogatories, is when you want to ask the other questions on oath. So the person comes and you are given a chance to ask him questions on oath. So those ones is what we call interrogatories. So discovery arises where, for example, you have sued me and I have a loan agreement, but I have refused to give it to you, and that's the most important document you have. You can proceed under what we call discoveries. Then inspections can arise where you want to, for example, a company, and I want to inspect the company's registrar or maybe some other documents. So we shall see at amendment of pleadings. How do you amend pleadings? And of course, pleadings are covered because there is an order in civil procedure which covers pleadings, and that's basically order 6 pleadings. And when you read order 6 through 19, it basically gives you under what circumstances can you amend pleadings. So we shall also look at summons for the elections, which we talked about earlier. that these ones can be extracted for you to get further directions from court. So by the end of this workshop, you will be able to illustrate the process of obtaining documents from adversary, illustrate the process of amendment of pleadings, illustrate the processes of taking out summons for directions, draft relevant documents in relation to processes subsequent in service of summons, recognize the issues relating to processes subsequent service of summons. Part A. Using the facts in workshop 1, you will counsel for Zara General Uganda Limited in view of the nature of their interest in the matter and in view of paragraph B of the plaint, where it is stated in the area, detailed report of bad expenses and receipts to be produced at the hearing. You have requested the plaintiff's lawyer to avail the above, but all in vain. Illustrates the process of obtaining the above documents and all the necessary documents. So basically here we are proceeding under what we call discovery of documents. Like the way I have told you, whenever you want to rely on a document but in the hands of the other party, so you can proceed by what we call inspections, and then a court can order them to grant those documents. So when you look at order 1024, applications under this order shall be summoned in chambers. So basically that means that the documents here, it will be a chamber summons supported by an affidavit. Then part C. Part A, documents, it's chamber summons supported by an affidavit. So part B. Assume as counsel for the plaintiff, your client informs you that there are other medical expenses that you forgot to inform you about. These include the cost of intensive care, a unit totaling to Uganda shillings 8 million. Advise the plaintiff on the process to ensure that these expenses form part of her claim and of the necessary documents. So basically here we shall look at amendment of pleadings, and I have said that amendment of pleadings are under order 6. Basically when you look at order 6 rule 19, the court may at any stage of the proceedings allow either party to alter or amend his or her pleadings in such manner and in such terms as may be just. So when you look at the procedure, they are saying that procedure under these rules, proceedings under rules 18, 19, and 22 of this order shall be by summons in chambers, and 19 shall be by summons in chambers. So basically that means that the document will be summoned in chambers supported by an affidavit. Part C, assume further that the parties to the civil suit have conclusively filed and exchanged their respective pleadings, illustrate the subsequent pretrial proceedings. So basically the subsequent pretrial proceedings, once you have finished that, you extract, once you have filed an affidavit of service, you extract summons for the elections. So in summons for the elections, you can seek discovery of documents like the way we have seen above. You can also talk with the registrar in case you need to bring in other witnesses, or in case you want to make in an amendment. But also the court sets the date for the scheduling conference. So after the extracting of summons for the elections, which is always before the registrar, then you go for scheduling conference. The scheduling conference is always before the judge. So once you have finished the scheduling conference, you now go for what we call the hearing of the case. So basically that's what we're going to be looking at. After an application seeking for the election deemed appropriate, so we are going to extract summons for the election. So when you look into your civil procedure rules, it has this structure of the summons for the election. So you just extract it, but it's in your civil procedure rules. So basically that's the analysis of the workshop, which we can give to you. Basically you have to make sure that you understand, but of course, like the way we are saying, that if you know that you don't have time but you have the money, you can come and join our mastermind group that has students from all the 4 campuses, and we have online discussions on Saturday as well as on Sunday, always from 8 p.m. to 4 p.m. We also give detailed notes on the workshop immediately. and it's a very good opportunity or mentorship programs for those students who don't have time but have the money. But also, if you know that you don't have the money, then I assume that you have the time. Then use your time very well, because you don't need, it's not mandatory that you must have mentorship at LDC. It's only for the students who can afford it. And then if you don't have the time and the money, then I pray for you. God should be able to do you a miracle. So workshop 3, the facts in workshop 2, task 3 will be used by the end of this workshop. You'll be able to explain process subsequent service of summons. So we have said that after serving summons, you file an affidavit of service. After filing an affidavit of service, you proceed to extract summons for the elections. After extracting summons for the elections, you go for scheduling conference. After going for scheduling conference, you go for full hearing of the case. Then draw relevant in relation to processes subsequent to service of summons. One will have affidavit of service, then extracting summons for the elections. ISCO issues, we looked at several ISCO issues, including not overcharging your clients, duty of confidentiality, recusal for judicial officers, properly deponing all the affidavits, all things under the professional code and conduct. Then areas for your research, we have those cases there. Of course, we have the case of Gaso Transport Bus Company Limited versus Mountain Obene, a locus classicus on amendment of pleadings. The court discusses grounds that must be fulfilled for there to be amendment of pleadings. You must not cause an injustice to the other party. It must not have been in the knowledge of counsel. So if you want to understand the grounds for amendment of pleading, read the Gaso Transporters Bus Company Limited versus Obene. Then some other case, of course, I'm seeing here Geoffrey Gatete versus William Chobe. It's a locus classicus on service of summons to partnership. The court is saying that in a partnership, you ought to serve each partner, because you ought to serve to all the 4 partners in case the partnership has 4 partners. But it's a very good case also on service of summons under Order 5. So if you want to appreciate the law on service of summons, you can read Geoffrey Gatete versus William Chobe. So another case here, I think Nicholas Rusian versus Gurma Hussein. The case distinguishes between ex parte, between Order 27 on ex parte judgment, setting aside ex parte judgment. So the court is trying to distinguish how do you set aside ex parte judgment and ex parte judgment, because we have ex parte judgment under Order 27 and I think under Order 9 Rule 27 and ex parte judgment under Order 9 Rule 13. So the court is trying to make a distinction between those 2 orders. And then, of course, Mukisa Biscuits Manufacturing Company versus West End Distributors Limited. It also discusses the law on filing written statement of defense. Very good cases here. So we have an extra A summons file a defense, basically, which was served on 22nd January 2024. We looked at the impact of that, and we looked at basically at order 8, where we are saying that a written statement of defense must be served within 15, must be filed within 15 days. Then it's annexed the plaint here. We see Natukunda Mbabas versus Zara General Uganda Limited under law reform miscellaneous provisions. So here the cause of action is this as the cause of action, and the facts constituting the plaintiff's cause of action, as we can see, the particulars of negligence were very well pleaded. The particulars of general damages and the prayers. So basically, that's how you draft a plaint. These plaints are very well drafted. You can always keep them for your reference, because you can never know when you need them. And it's supported by a summary of evidence. Summary of evidence always has a list of witnesses, list of documents, and list of authorities, together annexed with the evidence, the vehicle inspection report. Also have the postmortem report, or annexed to the pleadings. So basically, that's it. I hope this was very helpful. Please, if it was helpful to you, subscribe, like, comment, and share, and also turn on the notification button, that bell you can see, so as you can never miss anything. You can never know, anything can drop out here and you miss out. So please turn on that notification button so as you get all our analysis. I really wish you a blessed day ahead, and may you pass all your assignments and pass the IA for the week.